Thank you, everybody, for being here. I'm Bob Berukowitz. I'm the director of the Defender Initiative here at Seattle New School of Law. Today, we're having our 15th Defender Initiative Conference on Public Defense. We're bringing together Defender leaders, allies, and discussing with legislators what our state Supreme Court a year ago recognized as a crisis in public defense. We have a challenging situation in which, at the same time, we have some of the best public defense in the country with the highest standards, but also threats to the quality of that representation and major inequalities across the state. The court said that action was required immediately to address the crisis and to support quality defense representation at every level. They ordered that beginning in January this year, defender caseloads had to be significantly reduced. This reduction is to be implemented as soon as possible, reasonably possible, but with at least a 10% reduction each year. The crisis has many elements, all related to the heavy workloads placed on defenders. Under the outdated caseload limit standards first developed 53 years ago, attorneys were expected to be assigned up to 150 adult felonies or 300 to 400 misdemeanor cases a year. Because of changes in technology and practices, including body cameras and various forensic science developments, those numbers of cases became increasingly impossible for lawyers to be able to provide effective representation. For example, a lawyer in a misdemeanor case would have an average less than 5 hours to represent a client, to do all the research, investigation, preparation of briefs, negotiation with prosecutors, and trials. Clients with means would simply reject a lawyer who told them they had 4 or 5 hours to work for them. But we have expected court people to accept that level of representation. That results in innocent people being convicted and in longer sentences than judges would order if they had a fuller understanding of the client and the case. 1/3 of Americans have a criminal history, and 45% of Americans have had a loved one locked up. Public defense affects all of us. Almost everyone knows someone who's been charged with a crime. A 2016 focus group found that 61% of Americans support their own state spending more tax dollars to provide public defense. Washington is a leader in setting standards, but we lag other states in providing state funding. Because local governments pay almost all the costs of public defense at the trial level, cities and counties with smaller populations and in rural areas are not able to pay competitive salaries and have trouble attracting and retaining lawyers. Our School of Law has developed a hybrid hub program designed to cultivate homegrown legal talent in underserved areas of the Northwest. The need for increased state funding grows each year. Right now, the state only pays about 6% of the total cost at the trial level. We recognize the governor's call to cut the state budget, but there are ways to invest state money that can reduce the size of the increase in lawyers that we need to meet the new caseload limits. For example, the Law Enforcement Assisted Diversion Program, LEAD, which began here in Seattle and has expanded to multiple locations in the state and across the country, has been documented to save about $2 for every $1 invested. The LEAD model, now also known as Let Everyone Advance with Dignity, enhances safety, health, and equity by building a community-based alternative to arrest and incarceration for people whose unlawful behavior stems from unmanaged substance abuse, mental health challenges, or extreme poverty. More than 35 communities across the country have adopted LEAD, including Whatcom County. Different diversion programs, including helping people to get their driver license reinstated, can remove from court thousands of cases of driving while license suspended or DWS3. Those cases primarily result from suspensions caused when people are not able to pay their traffic ticket fines. But while Seattle and King County and some cities mostly never prosecute those cases as criminal, many cities and counties still do. That's low-hanging fruit. Alternatives to criminal prosecution could free up lawyers and reduce the number of new lawyers needed to meet the new court rule standards. When accused persons receive help getting treatment and housing, there is less crime and public safety is improved. And we cannot ignore the racial disparity that is interwoven with inadequate public defense funding. In the King County Jail, for instance, less than 40% of the people booked in recently were white in a county that is 61% white. In Washington prisons, Black people are 18.2% of the prisoners, but only 4% of the population of the state. Native Americans are 5.4% of the prison population and 1.7% of the state. Hispanic people are incarcerated at 1.5 times the rate of white people. We do not have to reinvent the wheel to provide structures for greater state funding. We have an existing Office of Public Defense that already has some grant funding. And we can learn from the state of Michigan, which after a major study and litigation, established a commission and now has more than $250 million a year in state funding for public defense. We look forward to working with the legislature and the governor's office to improve public defense funding. I'm now going to introduce my colleagues. First, Christy Hedman, the director of the Washington Defender Association, then Larry Jefferson, the director of the State Office of Public Defense, Victoria Bloomhorst, who's the director of counsel in Spokane, and Toby Marshall in private practice, who's been a big supporter of public defense.
Hello, my name is Christy Hedman, and I serve as Executive Director of the Washington Defender Association. Founded 43 years ago, WDA works to improve public defense through standards development, defender training and case support, and policy advocacy. I began my career with WDA in 1989, the year Washington first passed legislation referencing WDA's public defense standards and requiring counties and cities to adopt standards. That was a major step forward, but the original proposal to reward jurisdictions that adopted standards with state funding was not implemented. More than 15 years passed before the state provided even a modest amount of pass-through funding to local jurisdictions. In the meantime, WDA helped create the State Office of Public Defense and continued advocating for increased state funding, particularly in cases where the state, not a local prosecutor, served as opposing counsel, such as in family defense. Removing those cases from local government responsibility has helped reduce some of their local financial burdens. 25 years ago, press coverage of the crisis in death penalty representation and unequal outcomes across Washington helped draw the attention of the legislature, the Washington State Bar Association, and the Washington State Supreme Court. The Washington State Bar Association created a task force that then has led to the Council on Public Defense. Two key lawsuits, A&J at the state level and Wilbur at the federal level, made the issue impossible for state and local governments to continue to ignore. In 2012, the Washington State Supreme Court formally adopted public defense standards and required defenders to certify compliance, which was an incredibly important step forward, even though the state provided no new significant additional funding. The 2023 National Workload Study required the Council on Public Defense to update the WSBA standards to reflect today's public defense practice. The court's updated order gives jurisdictions up to 10 years to implement the standards. Additional pass-through funding to local governments is essential to help them meet that requirement. The standards have always envisioned fully staffed public defense offices, including paralegals, investigators, social workers, and expert services. Prosecutors, by contrast, can rely on the police for investigations and victim services to support those who have allegedly been harmed. In most jurisdictions, prosecutors, or in many jurisdictions, prosecutors are also better paid and receive government pensions. This imbalance is especially stark in systems that depend on contracted services or have chronically underfunded public defense. The Washington Defender Association, but WDA was created to address inequities in public defense, and we're still confronting the reality of justice by geography. Our services provide a critical backstop for defenders who may be solo practitioners or work in offices with little or no supervisory support. Our resource attorneys promote efficiency and quality representation through training and materials, so defenders do not have to reinvent the wheel. Our nationally recognized immigration project helps defenders advise non-citizen clients about potential immigration consequences and works to remedy harms caused when prior counsel failed to provide accurate advice. WDA's Incarcerated Parents Project also helps clients and families advocate for special sentences and maintain family connections. WDA supports a 50-50 funding split between the state and local jurisdictions to ensure shared accountability. In the next legislative session, we will advocate for a significant budget allocation for public defenders. Last session, the legislature had the opportunity to provide additional funding through the millionaire's tax or other means, but chose not to act. A fair and functioning criminal legal system requires balanced funding. The Supreme Court's mandate can no longer be deferred. Without action, the system will stall under the weight of lawsuits and defender attrition. Economically disadvantaged Washington residents and our communities deserve better. Thank you.
I believe we can fly. I believe we can touch the sky. I believe it because I've seen it. My name is Larry Jefferson, and I'm the director. I'm your director of public defense for the state of Washington. I believe that we can provide public defense because we already do in certain ways. At my office, we have a parent representation program that started in 2 jurisdictions and has now grown to be a statewide program that's nationally recognized. I know that we can do this because we have appellate contractors, which took on the debt penalty. And they won. I know that we can do this because the legislature has recently funded recruitment efforts for rural communities here in the state of Washington, and it has been successful. You know, it's our job at the Washington State Office of Public Defense to help local governments and public defenders meet these challenges. You know, I think that public defenders, we want to be like Mike. We want to be at the top of the half court, fly in the air, and slam it down. We want to be like Steph Curry and be raining down threes. But what does that mean when we're doing that? What that means is that we're meeting people on the most darkest day of their life. And that we are providing the best representation possible. But that best representation just doesn't happen within itself. Michael Jordan wasn't a professional on the first day that he played basketball. He had trials and tribulations, but he was recruited. Steph Curry had to practice and practice and practice. And so that's what we do at the Office of Public Defense. And so why is this important? We know about the Sixth Amendment and that everyone has the right to a trial. We know about Gideon's promise. And that there is a holy trinity that happens in a courtroom where you have a judge, you have prosecution, and you have defense. And defense is the only party that gets to talk to everyone. And so we play a crucial public safety role. How do you think people get into a drug court? They have to talk to a public defender. How do you think people get into a mental health court? They have to talk to a public defender. Right? And because these are important, because public defenders can go to trial all day. But we want that trial to mean something, right? Because crime is caused by trauma. And so we need to have social workers. We need to have investigators, right? We need to put all these things together for the people of the state of Washington. We work for you. And so public defense is a core part of the justice system. But we also live in the United States of America. And everyone knows that the more money that you have to pay for counsel, the more likely that it is to succeed. And so no one wants a public defender because they don't think you're putting any money into it. And so we need to make a change, to make sure that we're funding public defense correctly. And I just want to add that when we do that, we create expanded training opportunities for public defenders. So you don't have a public defender who was like me, who never went to a straight line training in the beginning of his career. We're doing that day one. That we're developing recruitment and retention strategies to attract attorneys from all over the country. And also that we're providing the technical assistance and consultation to our local counties. And just most importantly, this is a challenge that we all get to do together to provide the constitutional services that are required, and that we want to continue the success that the current Office of Public Defense has been able to provide. And we think that it's important that in Washington, that since we've been able to make some progress, that with additional partnerships between state and local governments, we'll be able to face the challenges that lie ahead. Thank you.
Good afternoon. My name is Victoria Bloomhorst. I am the incoming chair of the Washington State Bar Association Council on Public Defense, and I'm the director of Council for Defense, one of the 2 county public defender offices in Spokane. I have been a public defender in Spokane County for almost 20 years. I understand my county's desire to be tough on crime. I too want a safe community to raise my child. I am concerned, though, that being tough on crime to many may seem to mean only funding the police and prosecutors. But I can tell you that only funding one side of the justice system will have the opposite impact of being tough on crime. The reality is, public safety requires sufficient funding for all parties involved. When our legislator responds to a request for $100 million for cops, but does not reciprocally fund all the other system players, our communities risk the system breaking. That is not being tough on crime. And when cops make arrests, there has to be a jail for them to put the person they've arrested. And at that jail, there have to be guards and cooks and all the other people necessary to run the jail. And it's extremely expensive to house a person in jail and prison. In addition to the jail, there has to be a courtroom, the judge, a bailiff, and a court reporter to hear the case. There has to be a prosecutor present to present the case. But what is lost on so many is there has to be funding for public defenders to defend people the cops have arrested. And not just the public defenders, our assistants, our paralegals, our investigators, and social workers. If our state continues to only fund the cops, the criminal justice system will break. Trials can be overturned on appeal because attorneys do not have time and resources to provide effective representation. And this only adds more costs, lengthy and expensive relitigation of issues, and no closure for victims. And even worse, it can lead to innocent people serving sentences for crimes they did not commit, which means the real perpetrator is free and able to continue committing crimes. The justice system is strongest when both sides are well represented. Wrongful convictions can leave the real perpetrator free while an innocent person is punished. Public defenders guard against that outcome. If you are serious about being tough on crime, you must fund public defense. Thank you.
Good afternoon. My name is Toby Marshall, and I'm going to briefly discuss 3 civil lawsuits that seek to address the public defense crisis in Washington. Each of these ongoing lawsuits comes at the problem from a different angle, but the underlying principles behind the suits are all the same. Any person facing criminal charges has a constitutional right to a lawyer, and that lawyer must provide effective, ethical, quality representation. And this takes time. If a lawyer has too many cases, the lawyer cannot do a good job on any of them. For that reason, the Washington Supreme Court has capped the number of cases that a public defender can take each year. And 3 months ago, in the case of in re detention of ME, the court ruled that these caps are mandatory and cannot be exceeded. Over the next 10 years, the caps will be gradually lowered, and by 2035, the maximum number of cases that a public defense lawyer can take will be less than half of what it is today. Accordingly, the number of public defense lawyers in the state and the funding necessary to pay those lawyers is going to increase more than twofold. The first of the 3 lawsuits focuses on the source of that funding. The case is called Washington State Association of Counties versus the State of Washington. Right now, our cities and counties pay approximately 94% of the funding necessary, which is over $220 million per year, to fund trial-level indigent defense services. The state pays just 6%. The counties in this lawsuit maintain that the state is responsible for all public defense funding and that the state can no longer delegate that responsibility to local governments. Our cities and counties are struggling to meet the need, and that struggle is only going to grow over the next several years. The King County Department of Public Defense, which is the largest defense agency in Washington, by itself, it accounts for roughly 40% of the total state budget spent on indigent defense. The King County Department of Public Defense has joined the lawsuit and is going to work with the Washington Association of Counties to hold the state accountable. The second lawsuit focuses on the independence of public defenders. The cases Bloomhorst and Charbonneau versus Spokane County. Plaintiffs Victoria Bloomhorst, who you just heard from, and Colin Charbonneau oversee the 2 public defense agencies in Spokane County. Last summer, they implemented caseload limit and weighting standards approved by the Washington State Bar Association. The Spokane County Board of Commissioners did not like this and adopted a different set of caseload limits and weighting standards. Those standards would require the lawyers in Spokane to take many, many more cases. And this would significantly reduce the amount of time that they have to give to each of their clients. For example, under the state bar standards, today, a public defense lawyer is given 105 hours to represent someone who's been charged with murder. Under the standards that the Spokane County Board of Commissioners has adopted, that same lawyer would have only 33 hours to represent the same client. Spokane County is pressuring Ms. Bloomhorst and Mr. Charbonneau to follow the standards that have been adopted by the Board of Commissioners, but the directors believe that this would be unethical and would violate a Washington Supreme Court order that prohibits any increase in caseload limits above where they were at in 2025. They seek a ruling that will allow them to continue with the state bar standards and also continue to use their own professional judgment and independence to determine how best to provide public defense services and not to let that be controlled by the Board of Commissioners. The third lawsuit focuses on the people who have the constitutional right to a lawyer but are failing to receive one. That lawsuit is Cuevas versus Yakima County. And it's a class action brought by the ACLU of Washington on behalf of 4 people who are being jailed and prosecuted in Yakima County without an attorney. The The ACLU is asking the court to fashion appropriate remedies for those constitutional violations, including the release of people from jail and the dismissal of charges. So these cases may seem distinct, but they're all interrelated. Without sufficient funding for public defense, our criminal justice systems cannot function properly. Excessive caseloads cause widespread constitutional violations, as was seen years ago in cases like Best versus Grant County and Wilbur versus Mount Vernon. The attorneys in those cases were each handling more than 1,000 cases per year. And in the case of Mount Vernon, this was on a 30% basis. So 70% of their time was spent doing private cases, 30% was spent doing public defense, and yet they were still handling more than 1,000 cases per attorney per year. The Washington Supreme Court has made it clear that is no longer an option. Criminal cases cannot move forward without public defenders, and the safety of our communities depends on sufficient funding to ensure that every person facing charges has meaningful representation. The alternative, this has already been seen in states like Oregon, Massachusetts, and Maine, is that thousands of criminal cases will have to be dismissed. And as a federal appellate court ruled in 2024, those in custody will have to be released unless an attorney is appointed to represent them within 7 days. The choice for this state is clear. We have two ways that we can go. One is to ensure public safety by providing public defense. The other is to ensure we lack public safety by dismissing cases and releasing people from jail because there is no public defender available for them. Thank you.
Thank you. We have about 15 or 20 minutes to take any questions that anybody has. We have a number of folks from around the state here to answer questions about other parts of the state as well. Are there any questions either in the room or on Zoom?
Sorry.
Okay.
Do you have like a dollar amount, like a hard dollar amount that you think that the state could provide that would at least, put the state in a better situation where it's not, collapsing?
Well, as Christy pointed out, WDA has supported a 50% approach. Right now, the estimate that the state OPD has documented is that it's over 210 million being spent now. That is not enough because of the dramatic inequities and lack of support staff around the state. But $100 million a year would make a huge difference in terms of supporting the cities and the counties. To give an example of one of the discrepancies that I learned about just recently, in Yakima, which is struggling with only one investigator and no social workers, but working on recruiting and retaining, they're paying $20,000 a year more than the defenders in Spokane are able to pay. That's not okay. And of course, it's probably more expensive in Spokane to live than in Yakima. And so that kind of difference has to be made up. So the existing total amount of money being spent is already not enough. But if we had half of that being contributed by the state, it would allow the counties and cities to increase what they pay, hire social workers, hire investigators, have more lawyers, reduce the workload.
And then can you talk a little bit about the discrepancy in pay between like somebody in Yakima, a public defender in Yakima versus King County? I mean, do you have like a range of how much more somebody in King
I think they're comparable. I'm going to call in my buddies from King to know if they know the answer. You can tell.
I don't off the top of our head, but we could get you that number if you need it.
That's Matt Pang, who's the deputy director in King County.
We can tell you, we get a lot of complaints that from other office directors around the state that King County or others are poaching their people just for that pure reason. Right?
Because of the pay.
It's got to pay.
Yeah. Thank you.
Jason?
One thing that's important to know too is that in different jurisdictions, people are paid in different ways. So in King County, there are employees, In Garfield County, they might be a contractor who's paid on a per case basis. So you're really comparing apples and dump trucks. You know, it's a good question, but given the very diverse delivery systems, it's really hard.
And there's also the benefits question. For example, at some of the defender agencies, they receive a pension or better healthcare benefits.
And a lot of the contractors don't have either of those things. And for nonprofit associations, and there's, I think, 5 in the state that do public defense, they may not have as robust retirement and health benefits. Any questions online? So cases Toby Marshall discussed currently being heard, is the expectation that any of those will go before the state Supreme Court. Toby, we want to answer that question?
The 3 cases that I've discussed are all currently being heard. The Bloomhorse case is pending in Pomeroy County. Is the Yakima case in Yakima County or is it in a adjoining county?
It was in Yakima County, but actually it's pending discretionary.
Yeah,
There's no
that's good.
discretionary reviews.
Okay, so the Yakima case arose out of Yakima County, but is currently pending before the Supreme Court as to whether they will hear it or not. So there has been a request made as to whether they'll hear that case, and we're waiting on an answer on that. And then Washington State Association of Counties is pending in Thurston County, and it has a trial date of 2027, so it's still quite a ways off.
And that's on remand from the state Supreme Court. Or the Court of Appeal.
From the Court of Appeals, yeah. So the case had originally been dismissed by the trial judge, but the Court of Appeals said that it can go forward, and it was sent back down a few months ago.
Thank you for that question. Any other questions? Sure,
I'm sorry.
no, we love questions.
I guess, what would you say to those who say that, the caseload standards may not be workable or that, there's too much, too low? What would you say to the criticism?
I could talk about that for a long time. I'll start by saying this. We've been working on caseload standards in King County and in the state for more than 40 years. The first time we had published standards was in 1982, the King County Bar. And at that time, we had a standard of 300 misdemeanors a year, which we thought was an improvement because, as Toby said, people were doing 1,000. But we know now that that's crazy. That results in not enough time, 5 hours per client on average, and a little bit more. And so what we have learned is that not just from our own experience, but from the National Public Defender Workload Study, which was done by the American Bar Association, the RAND Corporation, the National Center for State Boards, and a lawyer named Steve Hanlon, who's an expert in these matters. They spent a long time studying it. We then here in Washington, in our State Bar Council of Public Defense, spent another 2 years studying it and developing how to apply it to Washington. And we determined that we have got to make a dramatic change because the numbers we used to think 40, 50 years ago were okay are simply not. The practice has changed and our understanding of it has changed. And the expectation of the court, as in the Washington Supreme Court setting the rules on standards, is that we have got to adjust. So simply, for example, with body cameras at police, if 5 officers show up to a scene, there's going to be 5 videos that the lawyer has to watch. And sometimes it's helpful, and sometimes there's nothing there, but always the lawyer has to watch that. There's DNA evidence, there's cell phone tracking, there's all kinds of forensic things that didn't even exist when the original standards were developed. Even in 1982, when we did the work in King County, we didn't have those things. There were no cell phones. And there certainly weren't body cameras. And now there's security cameras everywhere that lawyers have to find, and all the social media stuff that you have to track on witnesses. And so the nature of the work has changed dramatically. So we know that in order to provide effective representation, you need a lot more time. Like Toby was saying earlier, it takes time to do the work. Just to describe the dozen or 15 elements of what a lawyer needs to be doing on a case is going to take time. And if just thinking about it, you need at least an hour up front in your initial client interview. If that client doesn't speak English, has a hearing issue, has mental health issues, substance abuse issues, it's gonna take longer. And you're gonna have to come back a second or third time just to establish a relationship with the client. Then you gotta review the police reports, and of course, if you have all these body cam videos, that's longer. Then you gotta negotiate with the prosecutor, you gotta research the case. You gotta go to training that Larry's putting on for people on how to do this work, and that Christie's folks are providing technical assistance on. It takes a lot of time to do this work right. I know it's not completely fair to analogize to doctors, but if you've got a brain surgery issue, you don't go to a doctor just out of med school to do it. You go to somebody who's been trained and has supervision and support, all the people in the operating room. We've got defenders across the state operating with almost no supervision, usually with no social workers at all, often with only 1 or 2 investigators for an entire office. And so people are triaging. Triage is not an acceptable practice for lawyers. Triage is what doctors on the battlefield have to do. It's not what lawyers should be doing when people's lives and liberty are on the line. Question on, do you see the best route forward for public defense to be properly funded, being through the 3 court cases? It seems like the state legislature hasn't been interested, and the clause providing some fundings was even cut. Yes, we discussed this morning with Senator Peterson, and we're going to be discussing again this afternoon. And my personal hope, speaking for me, is that the litigation will, as Christy pointed out, catch the attention of the legislature and help them realize the importance of it. The 3 court cases by themselves are not necessarily going to provide the funding that we need, but it may provide some encouragement. And to the extent that they're successful, it'll take us a big step forward. Let's put it that way. Thank you for pointing out. Any other questions online? Yes,
Not a journalist, but I just have.
you used to be one.
I did used to be one. This feels very natural. What are the counties that have the biggest defender shortages?
Biggest shortages
Yeah, counties in Washington specific.
in terms of people, you mean, or?
Yeah, US defenders for the cases that are in need.
I think that's a tough one to answer, and as one of the things that Jason has said in multiple fora, at least Jason Schwartz was Nobles County. Nobody really knows the total amount for sure of how many lawyers there are and how many cases there are. You can certainly say that in Yakima, where they weren't providing lawyers for dozens of people for periods of time, there's an issue. I think the same thing happened in Benton. In Clark, 24 cases were dismissed because there were no lawyers. There's been lots of places around the state where cases have been postponed because there's no lawyer. And I don't know that anybody can say which is the worst or which is the greatest number. And of course, depending on the size of the county, the proportion of it, 24 cases in Clark is different than 24 cases in King. Anything else? Really appreciate everybody being here. All the defender leaders and allies, we would love to take a picture of you up front for our SU publicity, if you'd like to join us up front.